Good afternoon to all the attendees. I formally welcome you to the Nalsar Pro Bono Guest Lecture Series 2025 to 2026. Firstly, I'd like to invite Professor Ashwini Sir to briefly introduce the Nalsar Pro Bono Club and the Nalsar Pro Bono Guest Lecture Series.
Good morning, all. First, I would like to thank all of you for attending this program, and I would also like to thank Advocate Nipun Saxena sir for graciously accepting our invitation within such a short time. And I was also following your spectacular cases, which are having tremendous impact. And I am very thankful that you have personally taken your time in your busy schedule and agreed to speak and deliver a lecture, sir. Next, let me briefly introduce what we are doing with our Pro Bono Club in Nalsar. In Nalsar, there are quite a few clinical program activities which are going on. The Pro Bono Club activity is one of the activities which I am in charge of. The other kind of there are many activities like Animal Law Center, Prison Law Clinic, Juvenile Justice Programs, Family Law Clinic, Child Welfare Clinics, and so on and so forth. As far as Pro Bono Club Clinic is concerned, I am in charge of it since 2014. We have started as part of Lion Poverty. I used to teach Lion Poverty Mandatory Clinic, subject and Lion Poverty Mandatory Clinic, and then I have established this Pro Bono Club according to UGC guidelines and Department of Law and Justice instructions. We actually had quite a few campaigns which we have organized, more than 60 campaigns. So in each semester, there will be students who will be dividing into 4 to 5 and form a one group, and they will be selecting a particular topic, and they will start a community awareness program through door-to-door awareness campaign. So they will be going to rural villages, and they will knock the door, and they will speak about the topic which you discuss, and at the same time, they will also do a small survey and collect the awareness and kind of information they have on that particular topic. Say, for example, we were doing on maternity issues. So alcoholism and maternity, legal awareness, and government schemes which are available. At the time, KCR kit was there. Some central government nutrition schemes were also present, where they are taking folic acid tablets regularly, where they are taking iron tablets regularly because anemic. So we do the campaign. We ask them where they are getting all the free, whether they are aware of the schemes, where they are getting their benefits. So it is a double-edged program where we speak about community awareness. We also inform them, and if anyone of them are not getting any of their schemes, we will immediately inform them where they can apply and get the benefit out of it. So it is a semester-wide program. We go and knock the doors, and we get the information where, say, for example, pregnant mothers are there from Anganwadi centers and other centers, and go and meet them also personally. And we go through many ways. So we have organized like 60, 70 programs, which all semester-wise programs. That is something which we have done previously. And second, we also have joined with District Legal Service Authority recently, and we had a small training session. And after the training session, Telangana State High Court, State Legal Service Authority has accepted to recognize our clinic program students as student paralegal volunteers. And me as a mentor paralegal volunteer, they issued us the identity cards. We are directly working under District Legal Service Authority as PLVs. As per Nalsar schedule, we have started it also recently. And the present area is that we are working on a Saki Center, one-stop center. So it is also one of your great contributions. And second, we are also planning to meet, first group is working on Saki. Second is police stations. Third group, where they will be helping people, especially with the idea that they need some kind of support. Many people who come to police station come for civil issues. They need some support, and we are willing to work with them. And we have also contacted the district panel lawyers for DLSA. They are also willing to help us. So we will be identifying the cases, take them to panel lawyers. They will immediately file the cases. Judge is also willing to give appropriate address as needed. He has promised us. And third, we are also working on labor issues. Labor issues where we are planning to move and meet them, where they are getting e-STEM card, labor identity cards, any compensation if needed, informing them about the government schemes, and see that they are enrolled in those schemes, so that when and if needed, they will get the benefits. That is the third program. And Nalsar University of Law, along with State Legal Service Authority, 3 years back, has started along with the LEAF. Again, it was our alumni we worked with 3 of us partners and started State Agri Legal Aid campaign. For the first time, we have trained 3 to 5 paralegal volunteers for 2 days in Nalsar, and Agri Legal Aid centers were opened across Telangana state. So they are only directly working with only on agricultural farmers issues. So that was the first of its kind, and later it was reported to Nalsar also, and we got State Legal Service Authority also told us that we got appreciation for it, and they are also planning to extend across India to have paralegal volunteers who work directly only for farmers. So these are some of the important works we have done so far. There are so many, but I think these are sufficient to introduce what kind of work they are doing. Of course, it's very small and regional, local level work we are planning to do and help them with, say, for example, they want to apply for bank accounts. They are not having, so we go and help them, take them to bank. They are having, say, for example, water tap is not there. So we go and help them in applying in a Gram Panchayat or municipal office and tell them to have water or sewage. So we are doing this kind of ground level work mostly. So this is the kind of introduction. And sir, you are second person we have invited, and I am very happy again. I formally again invite you, sir. Sandeep, please take over. Thank you for.
Thank you, Professor Ashwini, for your introduction of the Pro Bono Club. Let me introduce our speaker for this session, Mr. Nipun Saxena. Firstly, who has very graciously accepted our invitation at a very short notice. Sir is a distinguished advocate practicing before the Honorable Supreme Court of India, with appearances across high courts and major tribunals. He has argued in major landmark matters, including the Delhi gang rape PIL, which is the Nipun Saxena versus Union of India, leading to the creation of the Victim Compensation Fund and one-stop crisis centers nationwide, as well as the recent 9-judge Constitution bench in RE Property Owners Association and the Vijay Madan Lal Chowdhury PMLA review. His expertise spans constitutional law, international arbitration, digital privacy, data protection, special criminal legislations, and high-stakes civil disputes. He is also a visiting faculty at NLU Delhi and advises governments, corporations, and institutions on critical policy and legal issues. Let me lay down a few session guidelines for our viewers right now. Firstly, the session will run for around 1 hour, including 15 minutes of Q&A. All participants will remain muted during the session. Please use the chat box to type your questions or raise your hand during the Q&A to ask the question directly. In case any questions have been left unanswered, you're welcome to email us your questions and we'll try to get them answered. Sir, on to Mr. Nipun Saxena, sir, now.
Thank you so much to the Nalsar Pro Bono Club for inviting me here to deliver my session. Professor Kumar, it's a pleasure listening to all the great things that the Pro Bono Club has been doing. I think you have epitomized what Professor Madhava Menon once said, that when you are islands of excellence in a sea of mediocrity, it is these islands of excellence that are working on all frontiers, whether it be at a district level, at a regional level, or at national level, to do whatever you are doing in furtherance of the social engineering objective behind, which was the precursor for establishment of national law schools across India. And of course, Nalsar, to that extent, is leading by example. And I'm very, very happy and proud to note that. Also considering that both National Law University Delhi, which is my alma, and Nalsar University of Law were established by the same founding vice chancellor, we have a tremendous sense of belonging. We are sister law schools in that sense of the term. So it gives me a great pleasure to see and hear about all the accomplishments that the Pro Bono Club has been able to do, and I wish it Godspeed. Now, the topic that I've chosen for my discourse today has very much to do with fundamental rights and also the incursions that are being made by the state. Why it is also very relevant in today's time is also because you would find newer and modern ways to encroach upon fundamental rights. Right? The traditional days of locking somebody up in police station and beating them is, far behind us. Although you would see certain examples still lingering, around. But there is a new version, as if it were, for state excesses that has come into the fore. And it is to that extent that I would be focusing my discourse. The first thing that comes to my mind is that how do you visualize fundamental rights? The traditional notion of fundamental rights being available against the state is also something which has undergone a sea of change, right? In Z telefilms, you would have seen that a writ remedy will also lie not just for encroachment of fundamental rights, but other legal rights. Now, why other legal rights become slightly important is because you have now a right of property. Unless and until the property is elevated to the status of housing, at which point of time Article 21 kicks in, your property could be anything. Your property could be your offices, your property could be other establishments of like nature, which may or may not enjoy the status of a fundamental right protection, but would nonetheless be a constitutional right. Of course, you are already aware of 300A and so on and so forth. But today I'm going to talk about different ways and means in which the investigating agencies are now trying to, bypass the constitutional mandate which is imposed on them. The first thing that comes to my mind is, of course, the criminal justice administration system. When the Code of Criminal Procedure, CRPC, that is to say, was conceptualized, right, way back in the year 1894, with the first draft which was being laid down, every single person who had stayed in India, whether it be the Britishers or otherwise, had come to a very unequivocal conclusion that they cannot simply trust the police. Now, if they cannot simply trust the police, they had therefore built in what you call inherent safeguards within the CRPC to ensure that somebody's fundamental right is not taken away. Of course, back in the pre-independence India, they had no conception of fundamental rights. They only had limited rights which were available to the natives. But still, there were certain fundamental protections, let's say, which were inherred within the CRPC, which came to be. Now, in the year 1973, of course, contrary to popular narrative which is being set up, that it was a colonial relic, as if it were, from 1947 to 1973, there were close to 17 law commissions which had deliberated every provision and came out with the CRPC that you see today, right, prior to its repeal. Now, what were those fundamental guarantees and what were those fundamental protections versus how the police and the investigating agencies are trying to bypass it is something that we will very briskly cover, right? Because I've been asked to confine everything within 1 hour. So please bear with me if I'm going to throw a lot of provisions towards you, right? Because in addition to the 500 plus odd provisions of CRPC, we have the DSP Act, the ED, the provisions of the PMLA, the NIA Act, etc., UAPA. So I will try to take it on a thematic basis rather than going provision-wise, right? First thing that comes to my mind is, of course, the very registration of offense, right? Now, under the previous regime, which is the CRPC, you had a specific protection which was involved, right? 2014 to SCC 1, which was Lalita Kumari versus State of UP, a constitution bench of the Supreme Court held that if there is an information which discloses the commission of a cognizable offense, it has to be registered, no questions asked. If the police officer refuses to register it, then there will obviously be repercussions that would follow. Departmental inquiry, as well as in certain heinous offenses such as rape, there could also be criminal exposure to proceedings. Right? That was the law which had been fructified as of 2014. But comes 2023, when all these laws have been taken a backseat, right? Why? Because of the inclusion of this very interesting provision, which is called Section 173, subclause 3 of BNSS. Now, under 173, subclause 3 of BNSS, if the offense is punishable up to 7 years, then this gives a carte blanche power to the police officer to first carry out or conduct a preliminary inquiry. Now, you and I both know what a preliminary inquiry in such cases entails. Now, if it's a cognizable offense in which you have the power to even arrest or at least to register the offense without anybody's asking, then this conception of preliminary inquiry itself is problematic. Now, many people, the proponents of bringing in, try to rely on the same judgment of Lalita Kumari to say, oh, but it was permissible. Well, it was permissible in a very limited category of cases. The first limited category of cases was if it arises out of a matrimonial dispute. Now, if it arises out of a matrimonial dispute, then the protections under Anish Kumar, etc., are already available to you. Namely, that the police officer before arresting will have to issue a notice under 41A of the CRPC and its equivalent provision under the BNSS, calling upon you to come and tender your information. No arrest would be automatic. But what happens in such cases is, if you have given the power of to the police officer in the form of a discretion to first conduct a preliminary inquiry, that will throw open the doors to an institutional corruption. Now, if I have two provisions that I can book you under, right, it is my prerogative to book you in a lesser provision rather than one which entails a higher punishment. Right? So now I will call in the complainant and I will call in the accused separately, of course, and I will try to strike a deal as a police officer. Right? Whichever side is able to pay more or has more political clout or has more, privilege by their side, wins me over, and then I will appropriately formulate the complaint which is given to me, right? And naturally, of course, I have to do it at the instance of a DSP level officer, and I have to inform him. But all those forms of supervision are absolutely rendered, infructuous in a case where there is a lot of money and a lot of political clout, right? If police officers are not to be trusted, then it does not matter whether it's an SI officer or whether it's an IG, right? It has to have a semblance of judicial supervision. Now, how does it affect us, citizens like you and I? Because the moment we step in the capacity of a complainant or even an accused, it has a problem in that sense, because there are close to 86 offenses, from criminal breach of trust to outraging modesty of a woman, which is also implanted into the new BNS, right? I'm using those expressions. I personally hate that term. But, from that to offenses against the state, the new revised version of sedition, etc., all fall within the sweep of this discretionary power that is to be exercised. Now, if a powerful politician were to call somebody else and say, look, book X under these provisions, then that would be done almost instantaneously. But let's say in case a person hears from a minority and says that, look, somebody made a hate speech on account of which the people were agitated and decided to burn my house down, that may not pass the muster of a preliminary inquiry to carry out or to register an offense subsequently, right? So all the fundamental guarantees that were given courtesy Lalita Kumari have now been done away with. Now, this is the initial step of registration of offense. Now, when we come to investigation, there are certain more problems that we would have to tackle. The second problem that comes to my mind is handcuffing. Very interesting. Now, handcuffing, there were multiple judgments that you already know. I mean, I don't have to trouble students on Nalsar with a DK Basu or a Sunil Batra versus Delhi administration. There were far and wide judgments that had noticed that handcuffing is both inhumane and it is it deprives somebody of their dignity, which is fundamental under Article 21, and it has to be resorted to only in terms of the police manuals. namely that permission has to be sought from a requisite superior officer of the police department to ensure that handcuffing has to be carried out or not carried out, and that too has to happen to a certain category of offenders, namely whether those offenders are ones who are habitual offenders and who are all accused of very heinous offenses, and they also have prior criminal records. That is to say, they are history sheeters with at least 2 or more convictions. Now, those were the safeguards under which a limited category was carved out. And this was not carved out under the CRPC. This was carved out under their special police manuals or police acts. Right now, what happens is in 2023-24, we come out with the one-of-a-kind situation where India has been taken back 40 years of jurisprudence of 1980s has all been given a go by specifically incorporating provisions of handcuffing under section 43 subclause 3 of BNSS. Now what it does is that it essentially empowers, it identifies 2 categories of offenders. It says habitual offenders or repeat offenders. Now it's very interesting that the expression habitual offenders is defined, but the expression repeat offenders is not. And they are not interchangeable because, of course, the legislature cannot use words superfluously. Therefore, both of them will have to be assigned a specific meaning. The moment you assign them a specific meaning, there is an obvious trouble, because repeat offenders, anybody could interpret to mean if a person is accused in multiple offenses. Now, let's say there is a case of dowry demand, a 498A, a domestic violence complaint against any individual. Right, it could be a mother-in-law, it could be a very senior father-in-law, right, who is about 70 or 80 years of age. Thanks to this provision, he could be handcuffed tomorrow. Right now, these are against settled fundamental guarantees that have been laid down by Supreme Court from time to time. In fact, if people believe that this is not being resorted to, let me give you a very, very recent illustration of this: Vihan Kumar versus State of Haryana. Right, this was a bench of Justice Oak and Justice Koteshwar Singh, before who a man was produced, and there were fundamental breaches and violations, which I will allude to in some time. But this judgment is slightly important because there was a specific allegation that when he was produced before the magistrate within 24 hours of his arrest, allegedly 24 hours, because he feels that it was beyond the mandate of 24 hours. So there was a violation of Article 22, there was a violation of Article 50, Section 50 of CRPC and Section 50A of CRPC, along with Section 57 of CRPC. But be that aside, the allegation here was that while he was being medically examined because he was of frail health or that he was beaten up, he was kept in a hospital. At the hospital, he was chained to the bed and he was handcuffed. Right, and there was an affidavit to that effect by the medical superintendent of PGI Chandigarh itself, to say that, look, he was handcuffed. Now that was, of course, a sheer breach of all the constitutional protections that were given. He was not one of those people who fell into that little exception that was carved out under various police manuals. But look, the argument that was canvassed by the state was that we are empowered under Section 43 subclause 3 to make to take recourse to such handcuffing. And this, and of course the Honorable Supreme Court came down heavily on these police authorities and said that, of course, there is a breach of Section 50, 50A and 57 of CRPC. Which now brings me to this very interesting aspect of these inroads which are being made into CRPC. All the protections that were inherently available to us are now being sought to be bypassed by superior investigation agencies like CBI, NIA, or ED. And how do they do it? They do it in 2 or 3 different ways. The first way in which they do it is by saying that CRPC itself is not applicable. And now there is, of course, a 3-judge bench decision in Vijay Madan Lal Chaudhary, which says that CRPC itself is not applicable to ED officers. Since ED officers are not police officers, therefore CRPC is applicable to police officers. And ED, by virtue of not being police officers, CDI is CRPC has no applicability at all. If they say it has no applicability at all, then that is a fundamental violation of Section 65 and Section 71 of PMLA Act itself. Because 65 says that CRPC is to apply, and 71 says that it is only to the extent of inconsistency between the two provisions that PMLA will prevail over CRPC, generally a specially bus non-derogate, all those line of judgments. But the moment you say that CRPC ceases to apply, why? Because ED officers are not even police officers, then you are opening yourself to a Pandora's box. Now, what are those guarantees that are available to us? Now, somebody says, and of course, that argument was canvassed by ED, which filed an intervention in the matter, or there were other matters in which such arguments are being made, that my power to arrest under Section 19 of the PMLA Act is distinct from power to arrest under Section 41 of CRPC and whatever its equivalent provision, the BNSS is. Now, if my power to arrest stems from Section 19, then I do not have the requirement to comply with the protections or the exceptions to the power of arrest, namely 41A, let's say. Anish Kumar versus State of Bihar clearly says that if the offense is punishable with an imprisonment which is less than 7 years, then you are supposed to send a notice to me and you will not make an automatic arrest. But does it happen under Section 19? No. The ED can go ahead and do it. And this argument was again raised in this very case, Vihan Kumar versus State of Haryana, where Justice Oak very meticulously culled out Section 19 and said that your protection of CRPC or its inapplicability is not the question. The question is that there is a constitutional protection which is available under Article 22. And if it stems from the Constitution itself, which is, of course, the Lex Locus Suprema, then it does not matter whether one special provision could entrench into fundamental rights. And therefore, Article 22 will apply irrespective of whether the arrest is made under Section 19 of PMLA Act or whether it is being made under Section 41 of the CRPC, or let's say if that powers of arrest is being under the provisions of the UAPA Act, right, or under DSPA Act, it does not matter. And therefore, an accused has a right to be informed of the grounds of the arrest. Those grounds of the arrest, there was a very interesting thing that happened in this judgment, is the first time that the relative or the dependent came to know of the grounds of the arrest was when the police submitted its application seeking remand. So in that application seeking remand, they had taken the grounds why the remand is necessary and what are the grounds of arrest. And that for the very first time were made known to the relative. And that the Supreme Court said is not sufficient compliance of Section 50A. As soon as a person is detained or arrested, that grounds have to be made available to him as well as to a person nominated by him. If you do not do this, then there is a fundamental breach of Article 22. Forget 50 and 50A of CRPC. Right? Now, let's come to other aspect of the case, which is law and order. Now, of course, we understand that law and order is a state subject, and it depends on the investigating agency which is carrying out the investigation in question, which is why there's an inherent restriction on the powers, let's say, of CBI to investigate. Now, that inherent restriction is, let's say, in the form of Section 6 of DSPA Act. There are federal issues involved. Let's say an offense which is committed in Calcutta has to be investigated by West Bengal police, or if it is committed in, say, Hyderabad, it has to be investigated by Telangana police. Now, Delhi police cannot come and do it. If they do so, then they are violating n number of judgments of the court in addition to express provisions of CRPC, namely those provisions 177 to 179, 180, which says that the power to investigate shall be the local situs where the offense has been committed. But what is happening is Section 6 of the DSPA Act, which says that you have to take prior permission of the state government. Prior approval and prior sanction of the state government is necessary if the CBI wants to investigate in a different state. This fundamental protection has been given a go-by the CBI. In multiple cases, FIRs are being registered suo motu, and I'm distinguishing them from those cases where FIRs being asked to be registered on the directions of High Court or Supreme Court. where FIRs are being registered suo motu by CBI, the fundamental protection under Section 6, which is in fact an expression of federalism, is given a complete go by. Now, why is this important? Is because federalism is considered to be part of the basic structure. The police's power to investigate an offense within its state or within its territory or within the local jurisdiction where the offense is committed is sovereign. Right from the times of King Emperor versus Khwaja Nazir Ahmad, 1946 Privy Council, that line of judgments is consistent, which recognizes the sovereign right. Now, all of this has been given a go by. Now, let's say for an offense or for an offense which is committed in Calcutta, CBI, whose zonal office, let's say, is registered in Delhi, is coming in and investigating the offense, making arrests, producing people in Delhi, whereas arrests are, let's say, being made in Asansol or any other place in West Bengal. So they are traveling 1100, 1600 kilometers. A complete go by to section 177 to 180 of CRPC. And whatever happened to the right of accused to a fair trial? Let's say a person only speaks Telugu, does not understand Hindi or English. What happens to that person? He is now being brought in to a place where the language of the proceedings also are not known. All the witness statements are either going to be in Hindi or English. And then that person is confronted with it. So that, I think, is really problematic, which to my mind is also, it stands on a different footing because of the new criminal laws which are set into motion. Your zero FIR ought to have corresponding changes in the BNSS. Now, people were very, elated when they say, oh, now, zero FIR is there. So irrespective of where the person is situated, an FIR can be registered at their instance. Please look at the effects test of it. The effect of such an investigation is going to create a Pandora's box on jurisdictional anomalies. Somebody who is living in Kashmir will get an FIR registered against a person living in Kerala. Who will investigate? The police in Kashmir or the police in Kerala? Suppose that person has to be apprehended and brought in. There were fundamental guarantees. Let's say if you issue a warrant and you have to get the warrant executed out of the jurisdiction of your state, then under section 79 of CRPC, you ought to take permission of the magistrate, go to the magistrate of the place where the jurisdiction is there, take a permission from that magistrate, take the local police in confidence, inform them, and on their endorsement, go there and carry out the arrest. Now, none of that will come into save you. All those fundamental protections are now completely gone by. And in fact, I have argued a matter where a person was residing in Gurgaon and he was taken away by Madhya Pradesh police without ever following those section 79 requirements, etc. So welcome to New India. Now, there is another very interesting problem with it. The power to compel appearance is vested in the police officers and in the ED officers. Now, let's say if it's a summon that you are supposed to comply with, then the powers to search, seizure, summon, etc. have also corresponding protections that are available in the CRPC, right? And by all means, they are constitutionally entrenched because they directly impact right of fair trial of an accused, right? And by fair trial, it does not mean post-trial things or those protections which are available to the accused during the trial. It also means and takes within its ambit pre-trial safeguards also, right? So now when this search, seizure, and summoning procedure takes place, it's also very interesting. Now, there is a fundamental guarantee which is inherent under section 160 of CRPC, which says that you cannot summon a person who is either sick or infirm, or is somebody who is above 65 years of age, or is below 15 years of age, or a woman. 5 different categories have been culled out. what has been mentioned is that if you want to summon those people, you must A, do it within the local territorial limits where they reside, and B, instead of calling them to the police station, it is the police officers who have to go to them. Right? And because this is only for the purpose of summoning. And we also know that under section 161, 162, and now under section 181, 182 of the BNSS, your statements that are being recorded cannot be used against you. Right? Because of course, any statement given to police officers is not admissible in a court of law. It's elementary principle that is taught in law schools across India. Now let's see how these elementary protections are being given a go by. Section 50 of PMLA Act clearly says that the ED can summon any person anywhere. If they can summon any person anywhere and they say that CRPC does not apply, then they can summon, and they have in fact summoned multiple people who are sick, infirm, who had surgeries, only to give their statements to Delhi. Let's say a specific politician was summoned from Kerala to come to Delhi, whereas ED has zonal offices in Chennai, it has zonal office in Bangalore, Hyderabad, it has a zonal office in Delhi and Bombay. But instead of calling them to the nearest zonal office, they decided to call them to Delhi. Another problem with this judgment, the Vijay Madan Lal judgment, is that it rests on the assumption that since ED officers are not police officers, therefore therefore the constraints or the territorial limitations of a police station does not apply to them. You can take it that what the judgment now says is that every ED officer is a walking police station. So if he decides to investigate you at X place, then he will investigate you at X place, notwithstanding that the fact that an ECIR is registered somewhere else. Now this is obnoxious, constitutionally untenable, and it's a direct affront to human rights of every denomination. Women, people who are sick, and people who are infirm are being called to tender their statements, say 1100, 1700 kilometers away from where they reside. They are being summoned without even mentioning whether in which capacity they are being summoned. Are they being summoned as an accused or are they being summoned as a witness? Because if they are being summoned as an accused, then Article 20, subclause 3, protection comes to their aid, protection against self-incrimination. But then the ED can say that I just issued a Section 50 summon, and therefore, if he did not know or he or she was not aware that they are being summoned as an accused or as a witness, then they don't have any way to save themselves from a potential self-incriminatory statement that they may give. There's also another problem attached to it, that those judgments in, say, Neelavati Behra and all those judgments, say Selvi versus State of Karnataka, in those judgments, it was also recognized that if at the time when you are being summoned, you are not being treated as an accused, then you would not be, then whatever you say can be used against you. Then the protection under Article 20, subclause 3 does not kick in. Because on the day on which you were summoned, you were not informed that you were an accused. Therefore, on that day, you were a witness. And if you have therefore volunteered any information, that can be used against you. But in CRPC, at the time when Selvi versus State and all those line of judgments came in, or Nandani Satpathy for that matter, the process of summoning was very different. Because under CRPC, you knew if you are being summoned under a 41A, then you know you are an accused, then you have to shut up. If you were being summoned as a witness under 91 or 160, then that was very different. Then you knew that you could volunteer information. And in any case, any statement given to the police officer could be against you. But now, if ED is not even police officer, then anything which is being given to them can be used against you. Number two, you don't even know, because Section 50 summon can be issued against any person. It does not identify, it does not carve out a distinction whether you are an accused or you are a witness. Then what do you do? Because if you do not give, let's say you can exercise your right to stay silent against any incriminatory questions coming your way. or potential incriminatory questions coming your way. But then section 63 of PMLA Act kicks in. It says that any person who is being summoned under section 50 is bound to answer the question truthfully. If you do not answer the question truthfully, or if you evade answering the question, then you will be liable for prosecution under section 63, read with section 174 of IPC, 63 of PMLA and 174 of IPC. So now you're looking at a jail term. So if I answer, I go to jail. If I don't answer, I go to jail. Because the person to whom I am answerable in this scenario is not even a police officer. Therefore, the protections, and of course, mind you, this is clearly against the judgments of Supreme Court. Tufan Singh versus State, where a similar provision of the NDPS Act was under challenge, where they said that NDPS officers are not police officers, the Supreme Court categorically came down heavily on them and said, what are you doing? How can you ask a person to give statement which can be potentially used against that person? The protection under Article 20 subclause 3 will apply irrespective. But you see, what is happening is that the new legislative schemes, or the manner in which so-called innocuous provisions of legislature are being misused, are trampling over those fundamental rights and guarantees that have stood the test of judicial scrutiny for over 4 decades, 5 decades. So where are we heading as a nation if these provisions are being unscrupulously misapplied? And of course, we have the result with us. The FATF, which is the Financial Action Task Force, which is the international body, has slammed India left, right, and center, saying as against those several thousand ECIRs that you have registered, your ultimate conviction rate is only 4%. That's abysmal. Right. Now, let's come to the last segment of it, because I've taken a lot of time on personal liberty. Let's also discuss property while we are at it. Right now, there's a new inclusion. We know that proceeds of crime are defined under section 21U of the PMLA Act. Right. Now, if property is said to be a proceeds of crime, or that it has been acquired on account of an illegal activity and then it is being washed off or launderized as white money, then naturally the provisions of PMLA kick in. But for that, there were essential guarantees. Now, one of those guarantees was that it could only be initiated, let's say a section 5 proceeding can only be initiated by a deputy director, who is a very high officer. Right? He has to record his reasons to believe in writing before carrying out the attachment of the property, or before declaring that these properties are involved as proceeds of crime. So any retention, any attachment, etc., had to be preempted with specific reasons to be recorded in writing, reasons to believe to be recorded in writing. Now, what usually happens is the reverse. First, they go and attach, and then subsequently they come back and record reasons to believe, which multiple times we have been able to demonstrate to the courts, and the courts have set aside the entire attachment proceedings as illegal. But be that as it may, you now have a new provision under the BNSS, which is called Section 107. Now, under Section 107, the proceeds of crime are defined exactly as they are defined there, except without any judicial oversight. Now, a superintendent of police sitting in any district can attach your property and say, oh, sorry, this is proceeds of crime. A provincial attachment had to be confirmed by an adjudicating authority under the PMLA Act before it was, and then it had to go before the special court, where you can well argue that, look, there's nothing to demonstrate that this was proceeds of crime, and you can get back your property. But the attachment by SP under a general law of proceeds of crime is disastrous, because A, it has no judicial oversight, B, you don't specify whether this is provisional attachment, or whether this is final attachment, or whether this is an attachment subsequent before the special court under 4446. So where do you go? Your entire personal property or assets are in danger of being designated as proceeds of crime. And do we not have false FIRs registered day in and day out? Somebody says that, look, you were supposed to pay X money for sale deed and the sale deed was not executed. Somebody registers an FIR against you and suddenly your entire bank accounts are being attached. And not under PMLA, but under a local law that we have every cause to worry. And lastly, I think I would be failing in my duty if I don't mention the recent judgment by Honorable the Chief Justice Gawai on demolition. People's houses were being demolished, their residences, on certain misgivings, right? Merely because their name featured in an FIR. Now, merely because your name is being featured in an FIR does not take away the fact that there is a presumption of innocence in your favor. Whether or not you are a convict will be determined subsequently. Then when the Supreme Court came down heavily on certain governments, UP government to be precise, right? They tried to give an affidavit saying, oh, they are not compliant with some building bylaws. They said that why did you act only after registering an FIR? If they were non-compliant with any building bylaws, etc., then you could have let them know some 20 years back. Why today? Why did you initiate all these coercive measures only today? And to deprive somebody of their house is something which is terrible, because a right to housing is also now recognized under Article 21 as a fundamental right. And the presumption of innocence has not yet been discharged in that sense, because it's still there. Now, to avoid that, the Supreme Court formulated 5 or 6 directions which were given to the state governments. It said that there has to be a 15-day show cause notice, and that show cause notice must have at least 5 or 6 things. One, the nature of violation. What have these proceedings originated from, under which law? Is it a building bylaw or is it just some coercive powers? Because CRPC does not entail this demolition as a form of punishment. Then what is the nature of violation? You have to give the particulars of violation, whether there was a personal hearing afforded to you in the past. If not, then mention the date of personal hearing which will be afforded to you in future. In that personal meeting, personal hearing, the minutes are to be recorded in writing, and just so that people do not backdate the notice, because they do that, they affix the notice by putting or changing the dates. They said that you have to immediately send it to the office of the DM, and the DM has to immediately issue an acknowledgement receipt of the same, so that backdating is impossible, right? And now that final order, let's say your personal hearing is also done and the final order is to be passed, that final order will not be given effect to for a further period of 15 days, thereby enabling you to knock at the doors of appellate courts, right? So all these fundamental protections are being staunchly fought for by the Supreme Court, because it is very cognizant of the fact that investigating agencies are doing things that are within their power to trample into the fundamental rights, right? I think I have I hope I have not exceeded my time, and this to me is something that I could encapsulate in the time that is allocated. So thank you so much for being very, very patient, and I'd be very happy to take any questions that you have.
Thank you, sir, for a very engaging session. If anyone has questions, either type them out in the chat or raise your hand and I'll unmute you. So we have a question from Rahul Shelar.
Yeah.
So investigating agencies, though not police, have to abide by the provisions of the Constitution. And if the Supreme Court has been questioning their arbitrary actions that are violating the constitutional provisions, then why has Honorable Supreme Court not laid down any precedent using Article 141 that curbs and keeps check on such actions, arbitrary actions of the investigative agencies? Why has the Parliament not been directed to amend the legislation governing these agencies? And why are the contradictory provisions of these legislations not being declared as unconstitutional?
Okay, let me take the third question first. Can the Supreme Court direct Parliament? It cannot. Right? There's no mandamus that can be issued to a legislature because they operate in separate fields. Right? You guys must have studied Montesquieu and separation of powers. So therefore, there is no mandamus to the parliament to do it. Now, whatever the law as it is in the present form was already challenged in Vijay Madan Lal, say in specific context to PMLA Act provisions. Other provisions of the new criminal law have not yet been challenged, but as and when they are challenged, you would find one of us arguing uh, for their exclusion. So as and when it is challenged, it would, all those things would fall for consideration. But there are certain aspects of, say the example that I gave you very recently about the power of arrest, right? So certain facets are being dealt with by the Supreme Court on a case-to-case basis. But if you feel that in one go, all these provisions which are scattered across the prism of different legislations would be decided, then the answer is a resounding. The court will examine them on a case-to-case basis and it will churn out. I'm sure that it would be aligned with the constitutional safeguards that are already there. Right? Now, what is the other question? Well, contradictory provisions of the legislation is not being declared as unconstitutional. See, they are. It's not. So there's one judgment, Union of India versus the state of West Bengal, where this very provision, Section 6 of DSP Act, is being given effect to. And a declaration is being sought to the effect that all these FIRs which have been registered suo moto by CBI must be declared unconstitutional. So there are certain portions, just as I said earlier, that in different cases, the Supreme Court is asserting the constitutional mandate.
So there's been another question, though it is not directly related to the topic at hand. So someone named Lakshmi is asking you what your favorite case has been in your practice till now.
Wow. Okay. My favorite case was a murder case, and I mean, I don't have favorites amongst murder cases. They are all my favorites because I try to do justice to them. But this one was particularly entrenched. It was a murder case where the person was languishing in prison for over 11 years, and that person had not committed it. His name was falsely implicated, and he was brought in by virtue of a coerced testimony of a co-accused. Right? So he was subsequently arraigned. And while at the what was typically very tragic in this situation was that he was implicated with the aid of 120B and 149 of IPC common object, right? And there were close to 6 other individuals who were implicated as accused. The High Court acquitted 2 of them, and now there were only 4 of those people who came to the Supreme Court. But by the time they could come to the Supreme Court, 3 of them had passed away. And this man, who was in his ripe 80 years of age, was the sole accused left in this scenario, right? And of course, he had barely any money to afford the high stake litigations that take place in Supreme Court. So while we did appear for him, we found out that there were elementary problems in the evidence collection, and which clearly point out that he was not even present. I mean, he did not even have to be examined in this 313. Only on a bare perusal of the prosecution, you could have come to the conclusion that this person was not even found at the scene of offense, right? But unfortunately, that was 9-10 years of imprisonment. So that case particularly was very close to my heart, because by the time we were able to get him some semblance of relief, he was already in a hospital battling life and death. Right? So yeah, these are bittersweet memories, but you do what you do.
So there's a question from Mr. Alok Kumar.
Yes.
There are long pending reforms in police reforms across the state. View on these police reforms?
Wow. Okay. That would require 1 hour, but let me compress it. You know that there is proceeding which is already pending before the Supreme Court, which is called the Prakash Singh PIL. In the Prakash Singh's case, there are various reforms that have been suggested. But you see, that's the difficulty. And instead of addressing the problem at an institutional level, what has happened is that you have brought in new gadgets and gizmos to carry out investigation, but without giving basic necessities to police officers. So, for instance, provisions of stationery, right? Provisions of fuel for a vehicle. Your district is about 120 kilometers, in area. You naturally have to carry out, for the purpose of law and order, you need to have to requisition, and you are being given a very dusty police station. I'm not talking about swanky police stations in the metropolitan cities. I'm talking about the Dehat Thanas, right, where they don't even have a computer. In fact, one of those gentlemen told me that, sir, the computer stopped operating way back, so we had to go back to our version of recording everything by hand in the register. And there are 17 or 18 registers, but the difficulty that happens is that, let's say, if you take a general diary register or a Roznamcha, right, if it is not being uploaded online, the very unscrupulous police officers will leave the last 3 rows empty, so that they can always backdate any entry that they feel to implicate any person or to give any undue protection to a person they want to be protected. So those things need an emergent remedial. Now, if you take an example of the latest controversies that have arisen, say a seizure has to be taken under 102 CRPC and now under the 105 PNSS. There's so much problem with it because your cameras have not arrived yet in multiple police stations. You now say that they have to be, the SOPs, by the way, say 30 megapixel camera, you have to take a 98-degree angle shot, and sufficient number of memory cards will be present. But I'm yet to see that happen anywhere. Now, the problem is, if this provision is mandatory under Section 105, that there's a chain of custody, that you have to now upload everything on the e-Saksha app, right? But there are, every seizure process at least takes 1 hour. Will you have a 1 hour of recording, and will the application not crash if you upload a 1 or 3-4 GB data immediately into it? These are problems. And by the way, 63 of BSA, which is the Bharatiya Sakshi Adhiniyam affidavit, now says that you need to have a proper chain of custody. Now, if there's any break in the chain of custody because the video was edited, or whether it was compressed, or whether more than one video clips were necessary to record the evidence, then your entire chain of custody falls flat in its face. So what is the net effect? The net effect is that the entire seizure becomes redundant. Imagine prosecuting a murder case where the weapon of offense is held to be not properly seized. So it's going to become very problematic for prosecution agencies going forward. When these trials, which are now ongoing in 7 or 8 years, come to the high courts, you would see a barrage of litigation where the high courts or the Supreme Court will be compelled to say that this 105 CRPC is not mandatory, it is directory. The moment it is directory, we go back to the age of CRPC. So you see, these protections are not, these provisions, these amendments are not really bearing any fruit.
So there has been, let us take one last question since we are running out of our scheduled time. So there's a question from Mr. Tushar Azad on what may have been the rationale behind bringing in the zero FIR.
The zero FIR. Oh, well, the rationale was for rape cases. And there was an MHA directive which was issued in the year 2013, immediately after Nirbhaya case, that it does not matter where the situs of the informant is. So long as she can register, she can go to the police authority which is nearest to her, she can get her FIR registered, which is fine. But the problem is that when you do it for every cognizable offense, it becomes problematic. The reason was that there would be one Mahila Thana, which would be given to a district. And to assess that, it would have made sense. And in the advisory which was issued in 2013, there was step-by-step guidance which was given to police officers. What happens if the person is out of district? What happens if the informant is out of state? What happens if the informant also came to the country to register the FIR, but it's a foreign national? Right? So in all those contingencies, everything was culled down by the MHA advisory. None of that has made its place into the amendment of CRPC. Please do not run under the assumption that I'm discrediting zero FIR for any reason. I'm saying if you had to have zero FIR, you ought to have brought in sufficient procedural, inclusions, amendments into it, so that how to carry out investigation if the information discloses commission of a cognizable offense originating from a zero. All those things are still not ironed out. And it is not to say that rapes are not happening in this country while the government takes its own sweet time to deliberate, or that any offense which is punishable up to 7 years does not happen in this country. Which I'm thankful for that specific question, because if you look at another provision under the new BNSS, which says that if for any offense which has to happen for which the imprisonment is over 7 years and above, there has to be a local investigation team which has to be deployed for the purpose of compilation and collection of forensic evidence. Where are you getting these forensic experts from? There is nobody. And then the check, or जिसको कहते हैं ना, bill फाड़ दिया है आपने state government के नाम पे, because now it is up to the state government which will have to notify in another 5 years. So does it mean that for the next 5 years India is not going to see offenses which entail a punishment of 7 years and above? It's just ludicrous. It's like putting the cart before the horse.
So thank you for taking the questions. I would like to invite Professor Ashwini to give the vote of thanks. Sir, you're on mute.
Okay, thank you, Sandeep, for informing me that I'm on mute. First, let me thank all the audience, and I would like to thank them for attending this program, which was organized within such a short notice. I would also like to thank the contributor, our advocate from Supreme Court, and Nipun Saxena sir, for responding to all the questions. Some of them are really broad, and some of them are also very specific. You have responded to them, and also for candidly explaining to us the problems which are coming from in the way of arrest procedures which are happening through various special acts, how CRPC is being not followed, how CRPC not being followed has been highlighted. I think that is one of the very interesting facts. And when I was hearing to your presentation, sir, I thought I also noticed something. I thought I heard, which is somewhat similar in nature. Last time when I went to DLSA, I was also speaking with one of my students who is working as a defendant for a panel league at DLSA. He told me that we have noticed, I mean, he was defending offenders for theft or something like that, who have cases of around 50, 100 theft cases. Now he says that maybe the guy maybe he came from Bihar or UP or some other place. He has he has very limited knowledge of either law or local language also. Maybe he did some theft, but not up to the level of 50 theft scenes, 100 theft scenes. I mean, police immediately, to show that we have, wherever the theft reports are filed, immediately recording and filing on this one person who got caught. I mean, that kind of tendency is something also is really surprising. And it is also something which was noticed when they speak among themselves. So it is a uniform pattern which was noticed across the state. I'm not sure if it is also the same pattern is being spent across the country, but I know that it is happening in at least Karnataka, because one of my students is again they're working there from Karnataka. I got the same information.
Professor Kumar, in Tihar, they are called midnight favorites. Sir. Because they are released at around midnight, and immediately once they are out, they are implicated in another.
Yeah, I mean, this was like a shock. I mean, the cases are also a theft he has committed here in one locality at 8 o'clock. And next locality, 10 o'clock theft also on his, I mean, the distance, practicality, logistics is just, I mean, it's apparent on the face of record. I mean, it is something which, when I was going through it, when you are talking about procedural safeguards, constitutional rights, and the situation which is happening, at least nowadays, these people are at least getting some kind of representation through the LSA. That is, at least some kind of benefit is happening to them, but 100 cases, resolving them and getting out on bail, it's a very hard process, sir. And second, I want to thank you specifically for your summarizing of so many points in such a short time. And I would like to end with a positive note that maybe people are also responding. People are also speaking about the kind of defects which are happening because of the lack of procedural safeguards and how constitutional violations are happening. Maybe something good will come out of this chatter which is happening in academic circles, with NGOs and in advocate circles, bar and bench. I hope maybe we will also get some really good judgments with proper guidelines, like when we got on, say for example, women protection at workplace. We got, it was one of my favorite judgments where we got some really good guidelines. I mean, it took more than 20 years for us to get an act. Maybe Supreme Court also will take a proactive stand, and I'm not sure with the present Supreme Court, maybe someone will take the step. And thank you very much for every one of you for attending this program. Thank you, sir. Thank you.
Thank you so much. Thank you so much for a wonderful session, and thank you to the audience. Why I thought I would dwell in greatest detail is because I'm talking to lawyers of tomorrow. And at academic institutions such as Nalsar, it is these thoughts that have to be, that have to be instilled, so that it develops critical thinking. Because unless and until we can question the status quo, we will not be able to come out with better solutions, as Professor Kumar rightly pointed out. Right. So thank you so much for having me. It was such a pleasure coming and speaking to you.
Yes. Bye.
Thank you.